Hi, I'm Miranda Salazar, a student attorney with the UW-Madison's Law and Entrepreneurship Clinic. I'd like to welcome you to the Small Business Development Center's Entrepreneurial How-To video series. Today, I'm going to give you a brief overview of trademarks and copyright. Trademarks, copyrights, and patents are sometimes referred to as intellectual property. Today, we'll be focusing on trademarks and copyrights. A question we hear a lot is, what's the difference between a trademark, a copyright, and a patent? It's a great question, and here's a summary. Trademarks protect your business name and brand. Coke, Nike, McDonald's are all famous trademarks. When customers see those trademarks, they can identify the business as the source of the products or services they want to purchase. Copyrights protect original works that you create, such as written content, graphic works, or music. Once you create an original work, no one can copy it without your permission. Whereas patents protect inventions, such as a new type of machine. You might be asking, how do I get a trademark? You obtain trademark rights simply by using your brand in commerce. Then you can develop your trademark rights in the same way you develop your brand, by using it in commerce to identify the goods and services that you're selling. You can obtain additional rights in your trademark by filing an application to register your trademark with the United States Patent and Trademark Office, often called the USPTO, which is a United States government agency. If the USPTO grants your application, you will have a registered trademark. As an example of trademark rights, if you sell Happy Feet shoes and people start to know your brand, they could be confused if another company starts selling Happy Toes shoes or Happy Feet socks. Those names are not identical, but they could cause consumers to confuse your products with products sold by another company. By causing consumer confusion, the other company would be infringing your trademark. Sometimes people ask us what's the difference between the TM and the R symbols that you sometimes see next to the brand name on products. TM means the company is claiming the rights to a trademark on the brand name, but the trademark hasn't been registered with the USPTO. The R symbol means the name is a registered trademark. You might be wondering, how do I get a copyright? You obtain a copyright in your work as soon as you draw it, write it, or record it. You don't need to register the new work with the government in order to have the copyright. You can obtain additional protection for your work by registering the work with the United States Copyright Office. As an example of a copyright, if you wrote an original song, you would have a copyright in that song the moment you wrote it down. If someone then copied your song, that person would be infringing your copyright. Now that you've got a good introduction on intellectual property, check out the rest of the SBDC Entrepreneurial How-To video series to help you build your business.